Welcome to The Real Recipe, the podcast that brings you the perfect blend of real estate trends and topics, where we serve up fresh insights and sizzling strategies. So let's get cooking. Well, welcome back to another episode. Today we're going to be talking about some fun and exciting estate planning and estate and trust and wills and everything you need to be doing with
protecting your assets.
Protecting your
assets. That's right.
Right. Covering your assets.
That's right. You should always CYA.
We'll CYA today. No, it's a good topic because I feel like this is one that a lot of people, as I'm sure you're willing to admit, right? A lot of people wait until it's almost too late to even do it.
Too late.
Yeah.
Like too late.
Like too late.
Yeah. Like way
Well,
too.
we're going to talk about avoiding all that. Nate Stein with us today, by the way, everybody.
Sorry.
Thank
Nate,
you, Nate,
welcome.
for joining
Yes,
us.
welcome.
Thank you.
So give us a little bit of background on you.
Sure.
Who you are and what you do, and we'll get into some fancy fun topics.
Yeah.
Absolutely. My name is Nate Stein. I'm an attorney, and I practice in the area of trust and estate law. My office is in Morristown, not too far from here.
Right.
A lot of what I do is help people plan for the future, plan for their eventual death. As we say, nobody gets out of this life alive. And there's a lot of things to protect.
Boom.
It's on his website.
Yeah. He'll be here all day, folks. He's here all day.
Love it.
Whether you have children, that's a reason to have a will. If you own any property, that's a reason to have a will. Real estate investors, I know that's a big segment of your listening crowd, and it's very important for people who own real estate, whether it's their personal home or investment properties, to have a last will and testament. So a will is, at its most basic form, a piece of paper where you write down and say, this is where I want my assets to go. Not only would a will say who receives your assets, those people are called your beneficiaries, but it also says how those people receive those assets. Meaning, if I pass away and I leave my money to my kids, do they get the money and they can put it in their pocket and do whatever they want with it? Spend it however they wish. Or would I want to leave my money to my kids and essentially have some strings attached? And I can do that through the use of a trust. To explain these issues, I think I'll chat a little bit about my personal estate plan to see how I thought about it. I have a very basic will that says if I pass away, all of my assets go to my wife. But if she's not around, everything goes to my two kids, and my kids are teenagers, 12 and 15. And if they were to receive an inheritance, that would be a major problem. They don't have not even close to the maturity, financial wherewithal to manage an inheritance.
Sure. Let's give a 15-year-old a couple $1,000,000. Exactly. What could go wrong?
He turns 18, he'd go on the world's greatest spring break vacation, and that's just not what I want to have happen.
Right.
What I really want to have happen is for my kids to get the benefit of the money, but not have the management of the money. And that's where a trust comes in. A trust is a way to split up the ownership of an asset and the management of an asset, with splitting it with the person who gets the benefit of the assets. So what my will says is if my assets go to my kids, it goes into a trust. And my brother is a trustee. He's an adult. My brother gets to manage the money. He gets to decide how the money's invested. He also gets to say, very importantly, when money should be given to my kids. Say my son turns 17, he just gets his license, and he says, Uncle Sam, I want to get my first car. I want a Ferrari. I need somebody to say no. I need an adult in the room to do something practical. My brother would say, no, you're not getting a Ferrari, but we can use the trust funds to buy you something more reasonable, maybe a Toyota, because not only do we want you to have a car, we want you to save for college. And essentially, my brother, as a trustee, would take over the role that I have now in doling out money to my kids to make sure they're supported, but to make sure they don't do anything stupid, quite frankly.
So you're putting a lot of trust in. Sorry.
Man.
But you're putting a lot of trust in the trustee.
A ton of trust in the trustee.
I'm a dad. That's what I do.
Dad jokes.
No, but in all seriousness, you're putting a lot of trust and faith in that trustee to dole out your assets to your children as they see fit.
Mm-hmm.
Yes.
Yeah.
Yes. Yeah. He's almost stepping in a role that a parent would have.
Yes,
Sure.
Absolutely.
Yeah.
Yeah.
Very much so.
Okay.
So it's important to have a will. I certainly come across people who don't have a last will and testament, but that that can result in really terrible problems. If you don't have a will, there's state law that says how your assets are split up, and it's basically a function of what relatives survive you and a function of how much you have in assets. But that state law is probably not what you had in mind, and frankly, it's probably not what you want to have happen at all. So it's critically important to put together a will together so everybody knows what's supposed to happen, and also to make sure that your wishes are followed, because this is your hard-earned money. This is your life's work.
Now, do you need an attorney to do a will? Can you do it on your own?
You can do a will on your own for sure, and there's certainly you'll probably hear them on the radio, LegalZoom, which
Right.
Well, because
like
that's
TurboTax.
like the natural. Just thinking from an audience standpoint, right? Like people are going to be like, oh yeah, I could just go on LegalZoom, or because now there's all kinds of websites that offer that service.
It's
for
exploding.
$59 or $29 or whatever, right?
And it's definitely going to be cheaper than attorney.
For sure.
But is it going to be done the right way?
But is it going to be done the right way? And then
Can they answer questions? Can they
right,
really
then,
answer
but
questions?
isn't there
for
like
you?
a recording piece of it too? Like, don't you have to have a will like recorded some way or something like that? Or
In New Jersey, after you do a will, it's not actually recorded with the state.
okay,
It's you just keep it. You keep it in your attorney's office. You keep it in your home.
but you have to be able to validate the date on it, right? I think so. Is that something with the date?
There's lots of signing formalities, which is part of that. And I'll tell you, if you don't observe all those signing formalities, it won't work. I mean,
Right.
Yeah.
say you do the
They
will,
can invalidate the will.
completely
You
invalid.
don't have 3 witnesses. You
Yeah.
have 2 witnesses, and one of the witnesses is a beneficiary. And then what happens?
You got a problem.
Right.
You got a problem. So, and that could be very expensive to unwind that issue. And
Absolutely.
I would argue that it's better to pay the money up front on an attorney, get it done right once,
Right.
and then
Right.
and
That's
then
what we
move
always
forward.
say.
Right. We
Pay the money up front, do it the
I know
right
you
way.
You did it right, and I'm sure I don't know if you did or not, but
Not yet. That's
But I
why-
mean,
that's,
certainly-
why, that's why Nate's here.
Certainly, where we see a lot of the things start to unravel is when people sell a property and the owner is deceased. And now you have, maybe they did have a will, maybe they didn't have a will, maybe the will was done incorrectly, and they go to probate the will, or there's no will, and they have to, assign someone to administrate the estate or whatever. And there's multiple siblings, and now you have people coming out of the woodwork that have to either get some type of benefit from the sale of this home, or who's going to take charge. A lot of times the caretaker for the person who has passed away isn't even the person who has authority to sign even something as simple as a listing agreement or make those decisions to transfer title. So that's really where it starts to unravel, at least when we see on our end. And not having a will outlined properly and going through proper channels just is, it can really turn into such a nightmare, because people get crazy when it comes to money.
Well, for us,
We all know that.
when we're buying from an estate, right? The first question is, okay, or one of the provisions is, you need to provide me with who the executor is or who the administrator is,
right.
and then get me those letters of administration or those letters testamentary to confirm that the person who signed the contract is actually authorized to sign the contract. That's the first thing I do when I see an estate as the seller.
Yeah.
That's what we need. And I tell listing agents all the time when we have these seminars, that's one of the first things you need to figure out. Where are they in the process of probating the will or getting letters of testamentary, letters of administration, because that's the person you need to deal with.
Well, so I guess one of my first questions to you is, how many people actually don't have a will? Like statistically, like what does it look like?
I've read all sorts of statistics on that, and I always question if they're correct, because
Why? Because it's such a big number.
Well, it's such a large number.
Like what?
Like
so what's the number?
75%.
It's certainly over 50%.
Wow.
Get out of here, really?
Yeah. Yes, absolutely.
Well, think of how many people that don't have a will. I mean, I
Wow.
can name 10.
So that means
my 10
statistically,
10 people I'm closest
Well,
with, I know probably
you know.
don't have a will. And they just got one done because someone in my family forced them to
Right.
do it.
no, but I mean, I guess that's the and especially on this topic, because obviously we're real estate focused, right? If you have real estate and you don't have a will,
Well, like you said, he's like
regardless of whether it's in an LLC with partners or anything else like that, you don't have a will. How are you dividing that? You're going to let the state
Decide who gets what.
Who gets what?
Right.
That's crazy.
And,
No,
and
it's
I actually
crazy.
have a quick story. Maybe I could tell it at some point during this.
Sure, go for it.
I was approached by a client. The man had been sick for maybe 2 years. He had cancer, and his accountant, who I'm friendly with, had been on his case to do a will. But I think in his mind, if he did a will, that would be like him admitting that maybe he was going to pass soon.
Sure.
So he procrastinated terribly. And then Eventually, he called me. He gave me a call on a Friday saying, Nate, I'm ready. The accountant's been on my case. I'd like to put together a will. So I asked him a few basic questions, and I mentioned some issues he hadn't thought about before. So he said, you know what, give me the weekend, and I'll talk to you again on Monday, and then we'll put in the will, draft the will, excuse me. And I'll say his case was just a little bit unique. He was on his second marriage. He had 4 children from his first marriage. One of those children he hadn't spoken to in years, and never wanted her to get anything. Wanted her completely cut out of the estate plan. Well, we spoke on Friday.
That's so sad.
I know. It's.
I hate hearing things like that because it's just whatever. Go ahead, sorry.
I agree. But we spoke on Friday. I posed some questions. He wanted to give it some thought. Think about it over the weekend. Monday we were gonna discuss and then start drafting. Well, Monday morning I got to work and he had died on Sunday.
I knew you were gonna say that.
So the man died without a last will and testament, and he had on a, like I said, second marriage, children from the first marriage. One of those children he wanted to get cut out. So what we had to do is look to those state default rules. They're called the laws of intestacy. It just means what happens to your property if you don't have a will. And based on his amount of assets and his family situation, essentially 60% of his estate was to go to his wife, and the other 40% was to be split equally among his 4 kids, each getting 10%. So the whole family knew that he did not want this one daughter to receive the assets. But since there was no will, the statute makes no exception for the fact that you have a bad relation.
Want or do not want certain assets
so
to go to
we had to write her a check for a few $100,000, and the other kids were furious.
I'm sure.
They knew Dad never wanted that to happen, but Dad never put it in writing. The other issue is Dad owned his home, a real nice home up in Sussex County, and he had 2 fairly valuable pieces of real estate in Jersey City. And he had mentioned to me, nothing was finalized, but that he would give potentially one property to one beneficiary and another to another. But here we're stuck in this weird situation where 60% is going to the second wife, 10% to each of the kids. And you can't really divide up real estate in 60, 10, 10, and 10. It's very impractical.
Right.
There's no way these kids want to be partners in the real estate with their stepmom. And there's no way the kids want to be partners with the daughter who nobody was even speaking to.
Right.
So we really had no choice but to immediately list the properties for sale and divide up the cash, because cash you can split up in percentages.
Yeah, right.
And not that there's anything wrong with selling property after a person passes away. Very often that makes sense. But here we had no choice.
Sure.
So I'll say his spouse and his children were actually very, very angry at him for not doing that and leaving them with this mess to clean up.
I think that's the thing we always talk about when you're, or at least if you're speaking to your family. It's like, you're really doing this to make everyone's life around you easier after you pass.
Yeah.
Like, so there are no issues, and everything is done the right way, how you want it, not how the state demands you split everything up upon you passing without a will.
Yeah.
Right.
So that's always the conversation. It's a tough conversation. Who wants to talk about you dying? Someday, look, we're all going to die. It's reality, right?
I guess I don't know.
It doesn't bother me.
It
doesn't bother me because I look at it as a business transaction.
Right, that's how I'm looking at it.
I need to do this to protect myself, my wife, my children, and my finances, and how those are split up, because I don't want them going to someone that I don't want them going to. Like, I don't want to go into my kid that I don't speak to.
But
I can't imagine.
To what we said earlier too, you don't want millions of dollars potentially going to a kid,
right?
And it's not going to be managed in a certain way.
Well, that too, right? Exactly.
Or
like I have
distributed in a certain way.
I don't have a will yet, but I have a 4-year-old. I have a 1.5-year-old. We own a house.
Yeah. And
we should have a will, because God forbid we pass. Where do my kids go? We both pass away today. Right?
Simple as testamentary guardians.
Right.
Who's in charge of raising them?
Who's in charge of raising them?
Yeah.
And where do all our assets go?
Yep.
Right. So to shift in back to real estate, though, from my perspective, and from Jackie's perspective, when we have a seller that is an estate, one of the things that pops up is inheritance tax, right? Filing the L8 or the L9, depending on if it's a real property or a co-op, right?
Right.
What do you file? When do you file it? Do I have to file it?
Mm-hmm.
Do you need it? But that's something that always pops up as a title issue.
Yes.
So, when do, as the executor or the administrator? When do we do that? Do I need to do that? If we're selling, if now we're selling a piece of property, and the title company is requesting that we fill out this estate questionnaire, now I call you, hey, you got to fill this out for me, and
right,
this is what they're asking me for. I don't know what the hell they're talking about.
Right. New Jersey has an inheritance tax.
Yeah.
It's a unique tax to me because it's not necessarily based on how much wealth you have when you pass away. It's based on your relationship to the people who are receiving your assets.
Mm-hmm.
So if you leave your assets to, say, your spouse or to a child, those are called Class A beneficiaries, and there's no inheritance tax imposed upon assets that go to them. But if instead of leaving it to your kids, you decide to leave it to, say, your niece or your friend, or maybe your partner, a girlfriend that you've been with for the past 20 years, you just never happened to get married, there's an inheritance tax imposed upon that. Now, if the asset is going to Class A beneficiaries, children, grandchildren, or spouses, you can just fill out that L9, and then it's filed, and that clears up the title. It's essentially an affidavit that everything is going to these Class A beneficiaries, and there's no inheritance tax on it.
And real quick, normally what will happen is if that L9 is not filed or received back yet, then you're going to say, okay, we need to hold an escrow.
Yeah, so it depends on we had a unique situation about this the other day. Someone was listing a property in New Jersey, and they were on the title with their father, joint tenants with the rights of survivorship. Their father had passed away in a different state down south. And a lot of individuals had told this man that he could not list the property because he had to probate the will first in that state, which can take, it's not like New Jersey, it could take several months. And he told me it was going to take like 6 or 7 months to probate the will. I was like, well, what county are you talking about? He's like, oh, no, he passed away in a different state.
Yeah.
So, and in order to get, a tax ID number, he had to probate the will, get a probate number for that. But he had held off on selling this property because they told him he was going to have an issue selling this. But it depends on how the property was deeded. Now he owns this with his father, all rights transferred to him.
So you don't have to worry about it.
Right. So you don't have to worry about it. But again, it just goes to show you it depends on how that property is deeded to. So sometimes they need to probate for other reasons also.
Right.
But when it came to the specifics of selling this piece of real estate, he didn't actually need to probate.
No, because he
that
owned it
estate.
as joint tenant, so it automatically
Right.
transfers.
So again, yes, but it's more specific to the individual sale of that real estate and how the property's deeded also.
Well, that's correct. But let's
Yes.
say it's just the father who owns it.
Yeah, we're going to want it.
And he passes away, and now you do the estate questionnaire. They file the L9, but now my client's rate lock's expiring. We need to close, but I didn't get the waiver back yet to tell us that there's no inheritance tax due.
And a lot of people,
You normally,
we would want to hold an
will call
escrow.
them and say, we're going to have to hold an escrow, and it's, I'm not sure how you guys calculate that, but it's normally a significant amount of money.
Well, and again, we just want to make sure as the settlement agent, if there's something that's due, this, state, fed, whatever it might be, that we're holding an appropriate amount, because otherwise, we're on the hook for it. So yes, we're going to want to see that. But most people don't even probate the will or go to the surrogate's court until they actually have to sell the property. A lot of times people are going into these transactions and then they're like, oh, I guess I have to get this done, even though their father, mother, sister, whoever it might be, passed away sometimes years ago.
Yeah.
And they're not doing this.
That's all the more reason to go in and start setting up some of the stuff ahead of time. Right? So you have, a trust set up, and you can distribute the assets how you see fit, or want them distributed. So
shifting gears a little bit, we wanted to talk, because we get this question a lot when it comes to buying properties in a trust. Give us some of the basics of that, ins and outs of that, pros and cons that you see on your end.
And why
Sure.
someone would want to buy in a trust as opposed to an entity or individually.
Right. Well, in terms of trust, there's 2 basic trusts that people use to buy property. One would be a revocable trust, and the other one would be an irrevocable trust. I'll start with the revocable trust, and that ties into what you guys were saying before about delays in getting an executor appointed. Or they're essentially just being nobody in charge of the estate. Nobody's there who can actually take action with respect to the house. Say you have a property that you're renting. You're the sole owner, and then you normally receive the rents and you make the repairs. But if you pass away, until somebody is appointed as your executor or administrator, there's nobody who legally has the right to do that. And in New Jersey, it's not a huge deal. Jackie mentioned this, that we have a relatively quick probate process. Say in about a month after somebody dies, I can get the letters of testamentary letter is issued, if they have a will and everything goes smoothly. In some states like New York or Florida, it could take many, many months. And in those states, it's extremely common to put real estate or other assets in a revocable trust. We do it in New Jersey too, but there's not as much as a compelling need. Here's the upside to putting the property in a revocable trust. If you put the property in this trust, you name yourself as trustee. So there's really no downside to you at this point. You can continue to manage the property, collect the rents, make the repairs. It's as if you own it directly. And in this trust agreement, you would say, I'm the initial trustee, but if I die, somebody else is the successor trustee. And the reason we do that is, say I pass away, I'm no longer the trustee. The very next day, my successor trustee can step up and say, I can take control over any assets that are in this trust.
Mm-hmm.
Right.
So there's no delay, not even that month delay that I was talking about
Right,
with
you're
New
not
Jersey.
waiting for any letters. You're not. That's it.
No,
Probate.
that's it. They can start collecting rents. They can start making repairs. They can use the decedent's money to make those repairs. So it really expedites the process, and that's the key reason people do revocable trusts.
Right.
It doesn't offer much in the way of, say, credit or protection, because the trust itself, whatever's in the trust, you're deemed to own because it's revocable. You could take the money out whenever you want. The trust instrument itself, you can modify the terms within the trust instrument. So there's not really a downside to putting in there. It just assists with the probate practice. The irrevocable trusts are very different. As the name suggests, once you create an irrevocable trust, it's very hard to change its terms. And also, if you are to put a building or a house, what have you, into an irrevocable trust, you should really assume that it's permanent. It's not easy to pull it back out.
Mm-hmm.
Most of my clients who are doing irrevocable trusts are doing it for two key reasons. The first one would be to minimize estate taxes when they pass away. Right now at the federal level, a person can leave a very large amount before there's estate taxes. In 2023, it's $12.92 million can be left before there's a estate tax imposed. And that number is doubled if you're a married couple. So if you're concerned about that, if you have assets in excess of that, we'll start gifting assets like a house into an irrevocable trust so that when you die, you are not the owner of that house, the trust is. So that asset escapes the estate tax system. However, for most of my clients who are, say, more middle class, they're not concerned about whether they have $13 million in assets. What they really care about is protecting their assets against the concerns of long-term care planning. You know, you work your whole life, you save money, you hope to have a comfortable retirement. But what happens if you get sick? What happens if you're so sick that you have to be in a nursing home and you're going to be there conceivably for a number of years? Nursing homes are extremely expensive. It can cost $15,000 a month to get nursing home care. And you have to pay that. You know, you could have saved, hundreds of thousands of dollars, but if you have a multi-year stay in a nursing home, all that money is going to go to your care. I mean, your kids you may want your kids to inherit your assets. So what we do for clients who have that concern is we create irrevocable trusts. And we often have them transfer their largest asset into that trust, which is their home. And the technique we use here is you make the transfer, you essentially gift the home into the trust. If you don't need nursing home care for a 5-year period after making that transfer, you're essentially not considered to have ever owned that. So whatever if you're paying costs to the nursing home, they can't come after that house. They can't say you have to sell that house to fund the nursing home. Or if you've spent down all your assets and the government starts picking up the tab in the context of a Medicaid benefit program, the government can't come after your home. Mm-hmm. So it's really a nice solution for clients who, you need a little bit of trust because you're giving your home, which is your castle, to usually your kids as the trustee. But if you do it well enough in advance, there's that 5-year look back, you can get all these government benefits for the nursing home. You could, get whatever services the nursing home provides. But the kids at the end of the day get the home free and clear, which is a great result. Now, some people want to do this simply. They want to do it themselves. And they say, well, rather than put the home in a trust, what I'd like to do is just keep it simple. Let me just deed the home over to my son and let him hold it. And it's out of my estate for Medicaid purposes. And if those 5 years elapses, I I don't have to look to that home. Nobody's going to consider me to own it. It's usually a terrible idea to do that.
Yeah.
Right.
I'm sure you guys.
I get that call all the time.
Yeah,
I'm
oh
like,
my
please
gosh.
talk to your accountant if you have an estate attorney. Well, I know they don't, because otherwise they wouldn't be doing that.
Right.
Right. Just two big reasons I have. First off, if your child owns the home and you get in an argument with your child, they could conceivably kick you out. You don't own it. You'd have no recourse, which would be a major problem. If we put it in a trust, we put provisions in the trust that say that the parents have the right to stay there as long as they want.
Right.
So that fear goes away. The second reason is, say you leave it to your child, that child owns the home, and then unfortunately that child happens to get divorced. Now that property could be the subject of a divorce claim by the
especially if it's a bad one.
Yeah,
oh yeah.
Yeah.
Oh yeah.
Especially.
But we also see that issue with capital gains tax too.
Oh,
because
yes.
a lot of times they're deeding it to their children
now
for
they're not getting
the
the
dollar.
basis.
right.
Yeah,
They're
they're
deeding
gonna
it for
step
$1, thinking, oh, I'm getting
big
older.
deal.
Just give it to my kid. I don't want to deal with it. And it's really sad, because we see a lot of this when we run title reports. Like it's evident with how the deeds come back and how they're deeded out that attorney just recorded that for them, and they just clearly got very bad advice.
Yeah.
But yeah, so several reasons why that is a terrible idea.
Yes.
Terrible idea.
Yeah. And you mentioned tax issues. That's huge. If I gifted a house to my child, and then for whatever reason we had to sell 3 years later, normally I would get the benefit of that $500,000 if I'm married, capital gain exclusion. But if the home is owned by my children and they sell the house, they don't get that because they don't live there.
Not only do they get that, but they don't get the step up in basis.
And they don't get the step up in basis.
Now,
Yes.
if you're 75, like, okay, my mom and my dad, who's passed, my dad passed, but when they bought our house in Brooklyn in the 70s or the late 70s, that house was probably $60,000. It's worth over $1 million today.
Wow.
So God forbid they were, my mom was like, didn't have this advice, or I wasn't an attorney and knew better, and just decided one day, I want to deed it to you and your brother. Now me and my brother are getting our base is going to be whatever they purchased it for, plus whatever renovations she did over the last 20, 30 years, as opposed to the step up value of $1 million when she passes.
You'd be looking at $900,000 of capital gains.
Right. So people don't look at, it's not just what's the estate implications, what's the real estate implications, what are the tax implications. They don't look at it that way at all. There's like, well, I need to transfer this now.
Right.
I saw an article on Facebook the other day, and it said that there's this 5-year look back, and if God forbid I have to go into a nursing home, they could take my house. So here, John, I'm deeding this to you. That's what people do.
Worst gift ever.
Yeah, right.
Worst gift ever.
Right.
Thanks a lot, Mom. Right. Yeah, worst gift ever. Like, so, and we, on a prior episode, we spoke to an accountant, and one of the things that we all discussed was not having the client speak to the estate attorney and then the tax attorney and then or the accountant and CPA and then the real estate attorney. It's you could speak to each of them individually, but then get everyone on one call.
Absolutely.
Because do not play phone tag. Do not play telephone.
Right.
As you as the client in between attorneys who are giving you legal advice.
I couldn't agree more.
Right?
Yeah.
So for something like that, where a client calls you up and says, or calls me up and says, I want to deed the property to my kid, I'm going to say,
nope.
Go speak to Jake.
Yes.
And then Jake will probably say, well, go speak to Nate.
Yes.
or I'll say, go speak to Jake and Nate, right? So,
right.
So, that's always, those are always the phone calls, by the way, where I need to tell clients, you need to go speak to X, Y, and Z before we do anything. And then we all need to speak to make sure that what we're doing all kind of gels together from each other's standpoints.
Is there a like an asset size, or value, from a value standpoint, like where a trust actually makes sense or doesn't make sense? Just trying to have a sense of like, you gotta maybe you're an older couple and you have maybe a house that's worth $600,000 or $700,000, right? Maybe you have 1 or 2 kids and you pass away. I mean, is that really a situation where you have a little bit of money in the bank, but not it's not a substantial asset or not a substantial estate, in any way. Is that something where you would still consider a trust or not? Or
I would suggest that I have a conversation with that person to get, find out what their wishes are to see if a trust makes sense.
I mean, outside of the Medicaid, Medicare aspect of things, which is valid,
right?
But outside of that, is there really any reason at that number?
And at that number, we don't have any estate tax concerns.
Right.
So we're not worried about there. If the money is going to the children, we don't have an inheritance tax concern.
Right.
So then the only potential trust I would consider is a revocable trust for them.
Right.
But if the husband and wife own it by tenancy by the entirety, it's going to go to the survivor without respect, avoiding probate.
Right.
And then I suspect, since it's not a rental, there wouldn't be a major concern about nobody being able to act with respect to the property for that month. The kids, if they're going to be the executor, could just wait the month, get their papers, and then contact the real estate and move on.
Yeah. I mean, other than the only real concern then just becomes the Medicaid.
Yes.
Nursing home, Medicare.
Right.
And completely mowing through that money in a matter of
a year.
Well,
maybe.
Yeah.
I mean, the average American doesn't have $100,000 saved in the bank, so you're blowing through that. I mean, $15,000 in a nursing home facility, that's like moderate care. Because honestly, to get good care, it could be much more than that. It's insanely expensive. So I mean, you're talking about blowing through life savings for people in a matter of months in some scenarios.
And I don't think a lot of people even understand that piece of it.
No.
The look back, the 5-year look back,
right?
And the right way to go about it.
Yeah.
What's the look back in New York? Do you know?
5 years ago.
Yeah. Well, I mean, this is a more complicated discussion. Maybe it doesn't apply to everybody. For their situations, but certainly, I mean, we've all seen the situation too, where you've got people who have substantial amount of assets in their name individually or in an LLC, no will, no trust, and you've got $20 or $30 million worth of real estate, and they've just done it. That's how they've done it. They've just done it that way.
It's worked so far.
Right. until it doesn't. Right. Until
but I think
somebody passes away.
But look, the
and
thing is, it's just the fact is, no one wants to have that conversation. I think a lot of people are just, whether it's a superstitious type of thing or they just don't want to, the morbidity of it. Like, they don't want to have the conversation about
years
dying.
Ago, I feel like that. I don't know.
But you're talking about these people though who, like, in their 50s and 60s and 70s, like, the superstition is a big thing. Yeah. Okay, and I'm speaking as an Italian person. Superstition.
I was just waiting for her to be like, well,
right, because
from
the
Italians on the side of the table.
But a lot of people are like that though. Like, a superstition does have, a lot to do with it, or a stigma has a lot to do with it. And they're like, if I start talking about it,
talking about
when I'm going to die.
Yeah.
Why? I don't know.
Because a lot of, like I said, a lot of people don't look at it like how I would look at it, like as a business transaction.
It's not a morbid conversation. I get it. I mean, it's
to you, it's not.
I mean, maybe I guess
people who aren't dealing with this on a regular basis as a part of, business transaction though, would maybe view it as
I'm gonna live forever. You see how I eat? You see my diet? I'm good.
I know, you're full of preservatives. We know you're gonna live forever.
Live forever or die trying.
Right. Thank you. Exactly.
That's like Brian's motto.
See?
But I mean, this is all really good information. Yeah. It's hard because no matter whether you have $100,000 in assets, or less than that, or hundreds of millions of $1,000s in assets, these are all things that you have to take care of in real time, because you never know what's going to happen. And
you should get a will. At the very least, get a will.
Well, I think,
and if you have assets, put it in a trust.
But I think sometimes more importantly than the assets are you have children, and it's like sometimes that's more valuable than your assets. So it's like, who's taking care of those kids? Like,
right,
who's taking care of my children?
You have a child. One of the next things you do.
I say that to my clients.
I
just
position
the
state attorney at the hospital. People are having babies, like
ambulance chasers.
No. When the photographer comes around, the next person that comes in is the estate attorney.
Yeah. Right.
I saw you just signed up for the top
just
photo
open
package.
up an office right next to the pediatricians and
we saw that you just signed up for a lifetime of worry and anxiety. While you're at it, why don't you just sign this paperwork?
Get ahead of this.
By the way, you're gonna need to get this. Yeah. So,
well, speaking of, real quick before we do wrap up, what is the standard, like when I go to an estate attorney, right? Hey, I want to get my will done. Am I just getting a will? What am I getting done in like that initial phase of my estate planning?
Great question. For the initial phase, I would recommend, particularly for anybody in New Jersey, to have 3 basic documents. First is the will, which we just discussed. But secondly, it's also important to do a living will and a power of attorney.
Yeah.
A living will covers healthcare decision making. Now, of course, while you're of sound mind, you're doing okay health-wise, you make all your own decisions. But God forbid you have an accident or an illness and you can't communicate with your doctors. We need a chain of command in place as to who's going to advocate on your behalf, and we do that through a living will. We also need to do a power of attorney. It's used in the same sort of circumstance that you use a living will, generally a situation where you had an accident or an illness. But here it covers financial matters, and you may just not be up to writing checks. You may not be up to going to the bank. And we want to make sure that somebody can use your assets to support you and the rest of your household, and that person is your power of attorney.
Mm-hmm.
So that's another opportunity to make a chain of command for somebody to take over in the event of an emergency.
Okay.
Perfect.
There you go.
So,
Well,
give Nate a call.
yeah.
Give Nate a call.
Get
Yes.
that
Because I'm gonna
will
tell you right
sign.
now,
Complicated issues
I
that you
am.
need
I will now.
professionals
I will
to
now.
help you with. Yes.
I only waited until we bought our second house and had 2 kids to,
Kids usually
And
expedite things like that.
What I think is a lot of people have the discussion of, I know I have to do it. I know I have to do it. I know I have to do it. But a lot of people end up getting to that point where it's too late. And, unfortunately.
Right.
So,
And if it really is true, like more than 50% of the people out there don't have
that's
wills,
scary.
that's scary.
Very scary.
Yeah.
For their finances and for their children and for just
Yeah. I mean, even just for the, if you have any sort of substantial assets, I mean, just the idea.
Don't forget, a lot of people have that. Not only A, I don't want to talk about it, but B, it's just expensive. It's going to cost me a lot.
Yes,
of money to do.
I mean,
But,
listen.
but again, the conversations we always have would be, it's better to spend the money up front.
Well, it's just like anything in life, right?
No, I'm saying we have these conversations all the time.
You pay for insurance. There's a reason why you pay for insurance, because when it happens, you want to have something in place. If you don't have insurance, the house burns down.
Right.
You out of luck.
Yeah.
Well, yeah, there you go.
So go get your estate plan.
Nate, thank you so much.
Yeah.
Oh, thank you.
Great
Yeah,
advice.
I enjoyed
Appreciate
this.
having you
Yeah.
on.
Yeah,
All
thank you
right.
for coming by.
Not the easiest thing to talk about, but
Here we are.
so it was good. We made it fun.
Yeah.
All right.
Till
Thanks,
next time.
everyone. Until next time.
Until next time.